Okay, let's get going. So, hi everyone. Thank you to everyone for joining us today for this webinar discussion on managing building safety, where, as you know, we'll be focusing on the in-occupation phase for higher risk buildings. I'm Rachel Kerr. I'm a partner in the commercial development team, and I help to head up the real estate building safety working party here at Gowling WRG. I'm going to chair today's webinar and hopefully ask lots of the questions that you're currently considering. So without further ado, I think it's time for me to briefly introduce the other panel members who will be joining in our discussion today. We've got Gemma Whitaker. She's a partner in our non-contentious construction team. She co-leads Gowling's cross-disciplinary building safety practice, and she therefore has a wealth of knowledge on all sorts of building safety topics. We've then got Danielle Klepping. She's a principal associate in our commercial contracts team, who, as well as having experience across a broad range of sectors, has specific expertise in the living sector and is well versed at looking at documents like PMAs. And then last but not least, we've got Natalie Barton-Howes, who's a principal associate in our health and safety regulatory crime team. And she focuses on helping clients to manage safety, compliance, and navigate enforcement action. And so she'll be able to talk more about the potential pitfalls. So hopefully we've got sort of the full spectrum covered for today's discussion. And before I hand over to them and they can share a bit more about what they do, I think it's worth taking a minute or two to just consider the focus of today's webinar, which, as you know, is the in-occupation phase for higher risk buildings. The definition of higher risk buildings we'll come to and touch on in the chat. I think it almost goes without saying that building safety is a really wide and complicated topic. And between the four of us, we share the feeling that a lot of work is going into interpreting really important legislation, which we feel is often untested and which feels like it's changing all the time and can make the topic seem dense and potentially difficult. So why have we decided to focus on the occupied phase now? And what do we want to try and get out of today's session? Primarily, we think it's the right time to move the conversation along to the in-occupation phase. And we think that's because we're responding to the increasing numbers of questions we're getting from clients. So you guys. We're very conscious that there are lots of different people watching with different roles and who might be at a different stage of what we're going to refer to as the building safety journey. But whilst there remain plenty of questions around things like impact on construction, the various gateways, registration requirements, our view is that people have an increasingly broad understanding of those, and that lots of people are now grappling with, or you're perhaps beginning to grapple with, how to remain compliant from an asset management perspective. So in today's chat, there's definitely an element of looking forward to next steps, as the title to the webinar suggests, and an element of horizon scanning. So hopefully that covers the timing. In terms of what we're doing and aiming to do today, I've already alluded to this, but we've set this up as a discussion between the four of us. I think it's important to reiterate that, and that we're having a conversation about the various things that we're seeing on our desks, as opposed to just presenting to you or providing specific targeted advice. And on that theme, given the nature of today's topic, I think it's really important for us to say we don't think we're going to have all of the answers to all of your questions in today's session. But what we'd like is for you to leave this webinar having an awareness of the sorts of topics we're dealing with, and so that you feel armed with the information. You need to frame the questions you want to be asking, and then the sort of questions that you want to be seeing and answering in respect of high-rise buildings. So in the next 40 minutes or so, we're going to use the experience we've accrued to date to explore the key aspects of the in-occupation phase by highlighting the approaches we're seeing across various living sectors towards compliance with the relevant legislation, as well as considering some of the pitfalls you'll fall into possibly if you fail to get your high-rise building ready and compliant. So with those outcomes in mind, I think it's the right time to get into the detail. And to kick us off, I think we'll look at that shift in focus towards the occupation phase. So if I come to you, Gemma, obviously you're our construction lawyer. You spent a lot of time in the last few years advising on the implications of the Building Safety Act around design and construction of new buildings, but we're obviously looking at that shift towards in occupation. What have you been seeing?
Yeah, I think it's fair to say the construction industry has really been at the forefront of the changes that have been coming out of the Building Safety Act. There's still a lot of work going on within the construction industry, getting to get grips with what that means in practice, and not to mention seeing how engagement with the building safety regulator through the gateway process for new works is going to play out. But we've definitely seen over the past 12 months or so a sharper focus being paid to the occupation phase for high risk buildings. So those with existing buildings have really been at the leading edge of that. So with registration becoming mandatory just over a year ago, businesses with those existing higher risk buildings in their portfolio have had to invest a lot of time in pulling together relevant information, putting together safety cases, and really making sure that everything's in place for the occupation phase. And now we're sort of starting to see that engagement with the building safety regulator where safety cases are being called in. And I do think there are going to be a lot of practical lessons learned from those early experiences about what it is that the BSR is looking to see. So the legislation isn't completely prescriptive in terms of exactly what some elements of the safety case has got to cover. So we're sort of gathering information as that process goes on to understand exactly what types of things building safety regulator is asking about. From a more specific construction lawyer's point of view, on the occupational phase, we've been spending a lot of time looking at the golden thread. So document handover for projects, particularly where they were already in flight when the regulations came into force last year. So they might not have gone through the new construction gateway process, but you still need that whole golden thread to be put in place for the occupation phase. And also where buildings are being acquired or refinanced, what are purchasers and lenders looking to see in order to be satisfied that the duties are being complied with and that those kind of all important golden thread documents are all in place. And of course, alongside that, we've seen a real shift towards providing advice on ongoing compliance around the management of buildings once they are occupied. So that's really where Danielle and Natalie have come in. They're really able to combine their existing specialisms with an in-depth knowledge of the BSA to help clients understand what those duties are during the occupation phase, and then take that a step further by putting in place appropriate management arrangements to support and then evidence that compliance.
Yeah, that's right. Just in terms of where I'm focusing on, I deal with all areas of safety management and compliance and the potential regulatory risk and risk of enforcement action. So one of the challenges we are seeing in my team is a confusion sometimes as to when and which duties apply in which circumstances. So you've got your fire safety duties, you've got the health and safety regime, and you've got this new layer of compliance of building safety. And all of these things can overlap and interplay with each other. And also all of them boil down to effectively managing risk. So being able to demonstrate compliance under the different regimes can sometimes be a bit of an exercise in trying to understand where and what scope of which duties apply. And also just how to do it effectively. That's a real challenge because are you integrating these new duties into your existing systems, and is that sufficient? And there just really needs to be some clear guidance on the approach, really.
I smiled in that answer, Natalie, because you said use the word confusion, and I think a lot of people who are watching probably agree that it is quite a confusing area of law, and I think we'll touch on that more as we go through the conversation. But I wonder if just before we continue, it would be helpful if we could perhaps have a broad overview of what we mean when we're talking about building safety during the occupation phase. Danielle, I think that's probably one for you.
Yeah, absolutely. It does cross over a little bit with fire safety because when we're talking about building safety, we are talking about risks from the spread of fire, but we're also talking about risks from structural failure. And both of those very much in the context of the safety of people in and about a building. And you mentioned earlier that we'd sort of outline what we're talking about in terms of high risk buildings. So we're talking about those risks to those people in the context of buildings that are sort of over 18 metres or 7 stories with at least 2 residential units. And there are other layers to that I won't go into now, but that's broadly what we're talking about today when we talk about high-risk buildings. So I guess going to sort of the specifics about the occupation phase and what we mean by building safety duties in that context, we're talking about the duties that fall on principal accountable persons or accountable persons in relation to those high-risk buildings once they're occupied. So you've got the building that's built and you've got residents coming into it. Broadly, they are sort of found in Part 4 of the Building Safety Act, and there's a lot of regulations that sort of supplement that as well. To sort of give you the sort of high level sort of areas they sort of cover. You sort of start with assessment and management of risk, so building safety risk. There's registration of high risk buildings. There's information requirements, reporting requirements, and then there's sort of a chunk of duties around resident engagement as well. So going into a little bit more detail around some of those. Accountable persons have general duties in sections 83 and 84 of the Act to show that they've assessed any building safety risks in relation to the relevant high-risk building, and specifically that they've taken all reasonable steps to manage those risks. So by that, we're sort of talking about steps to avoid them happening and steps to minimise them and sort of reduce the severity of them if they do. Then, as Gemma sort of mentioned, we have this requirement to register high-risk buildings so that the regulator is aware of them and can monitor overall compliance with the duties we're talking about. That came into force just over a year ago, and there's a specific process that you have to follow to register your building, which involves submitting some certain key information about the building to do with things like its height, its use, and also things like how many staircases it's got. There's sort of a list in the regulations around what you need to put in that. There's also a list in the regulations around some of these information requirements where you start to get into another area that Gemma touched on, which is the duty to have a building safety case report. That report is supposed to pull together some of the steps that you will have taken to assess and manage risk. So it's supposed to set out what you've done in terms of investigating the possibility of building safety risks at the building. And so there's sort of a list within the regulation of sort of areas you're supposed to touch on, and it includes things like what sort of specialist equipment you've got within the building and policies for maintaining and testing that. That also leads on to the golden thread, which I'm conscious we have sort of touched on in the sort of with a view to the fact that that starts in the design and construction phase. The idea of the golden thread is that there's sort of a single source of truth for the building. So it's this idea that you have all this valuable information that starts in design and construction and then is supposed to be maintained like an unbroken thread all the way across the life cycle of the building. I can't quite remember what Dame Judith Hackett's famous quote was, but that's basically where it stems from. And so there's a lot of detail in the regulations around what constitutes the golden thread and how that needs to be managed, maintained, handed over, as Gemma mentioned, not just at the construction stage, but if you sell or do anything with the building, and also how it needs to be made accessible to certain entities, including emergency services. There are some other information requirements in there around sort of changes of accountable persons, which I won't go into huge detail of, but there are requirements around information to residents, which brings us on to resident engagement, which I mentioned. There's a requirement to have a strategy for engaging with your residents and getting them to sort of talk to you about building safety issues. There's a requirement to have consultation when that's prepared and also when it's updated, and to consider any feedback that you receive through that process. And there's also sort of some linked requirements around sort of complaint systems and making sure that the complaint system allows for complaints about building safety specifically. So, I mean, that's a lot to get to grips with, and that's very much a quick tour of some of the main duties. There are obviously things in there I haven't mentioned, like the building assessment certificate process and some of the provisions that support accountable persons. So, yeah, there's a lot.
Yeah, I mean, suffice to say, lots of requirements, lots of detail for people to get their heads around. And actually, a lot of those requirements need balancing in a certain way. I think, Danielle, if you don't mind me sticking with you just for now, because you look at commercial contracts sort of day in, day out. So you're used to negotiating them. In terms of those requirements and how they're balanced between different parties, what are you seeing right now as particular areas of focus?
So you've obviously mentioned that I'm part of the commercial contracts team here at Gowling, and I appreciate that might seem a bit of an unusual fit for a webinar about building safety. My day-to-day involves looking at lots of real estate and living sector service contracts. So I have encountered building safety when looking at things like consultancy terms and conditions. We've had queries around tech providers, some data protection inquiries, but also a lot of management agreement and management appointment queries. So you mentioned earlier PMAs, it's very much the kind of thing that I deal with on a day-to-day. I would say at the start of the year, we were seeing a lot of queries and sort of inquiries about building safety case reports. Principal accountable persons are really looking for support with pulling those together, looking to appoint third parties to help with that, and then sort of asking about the terms of those appointments. We are still seeing some queries about that, and we're sort of seeing that where we perhaps have people that are a little bit earlier on in their building safety journey. We're also seeing it where there are more complicated developments because there were some regulations that followed the Act and included a bit more clarity about what we mean by a building in the context of a high risk building. And that's led to some clients who have, say, multiple structures or, structures that are split into sections asking a few queries. And that's sort of stemming to questions about, do I need more than one safety case report here? I think at the moment, I'm seeing more interest and engagement around residents and these resident strategies that we talked about a little bit. I'm seeing a push on managing agents to draft those strategies because they have the resident relationships. But I'm also seeing clients actively looking for managing agents to sort of suggest ways to get the residents to really engage, not just sort of read it and ignore it. And that's all sort of feeding into discussions where you've got a new building about sort of services in the management agreement that sort of help with this compliance area, and also a continuation of people looking to vary existing management agreements to include those services. So yeah, lots of things going on.
Lots going on. And you touched again, didn't you, on sort of people being on this building safety journey. And something that I've been asked about recently sort of touches on that. And it's about revisiting the registration in the first place and whether people need to go back and look at that now that they're in more of the sort of the weeds around the detail and the administration things. Gemma, would you say that people are revisiting, the registration process at all?
Yeah, I think it's fair to say we are seeing a bit of a trend of clients looking back at those registrations that might have been done in a bit of a flurry in 2023 when the registration deadline was upon everybody, with the consequence of criminal responsibility if you haven't registered by a certain date. Those registrations were rightly put through in time, perhaps without taking legal advice to check that they quite aligned with the legislation. And so some clients are looking back at those now and questioning, does that registration look right in light of what we know about the building and what we also know about the legislation? And I think one of the main reasons for that is that some of the registrations didn't necessarily take into account this concept that Danielle alluded to of independent sections. So where you've got that sort of mixed use structure and complex building, you might have a structure that can be divided down into more than one building for the purposes of the legislation. So a lot of care needs to be taken with this because there's specific criteria that have to be met. But if those criteria are met, then you can sometimes have an independent section that is purely commercial that could well fall outside of the higher risk building scope. So that's important to know and understand, both for the purposes of the occupation phase duties, but also for the purposes of which building control process are you going through for any future works to that building. Is it your sort of more traditional building control process, or is it your gateway process with the building safety regulator?
And actually, now you've mentioned building control, it's probably worth flagging, isn't it, that you've got all these management duties and obligations around high-risk buildings that we've talked about, but that doesn't supersede other pieces of legislations or schemes. And it's really important not to forget about the overall building control process.
Yeah, that's right. And I would say this is a construction lawyer, but we're focusing today on the management of building safety risks during occupation once you've got an existing HRB that you've got residents in. But I think it's really important that people who are managing those HRBs are really alive to the fact that that includes management of future works. So you can't just forget about that gateway process once the building is built and in occupation. If you've got future works happening, that gateway planning and building control process will apply to future works being done to that building, as well as to the original creation of the higher risk building. So anyone involved in procuring those types of works needs to be aware of that fact, and that they need to have processes in place to make sure that people carrying out those works are aware that they are working or designing for a higher risk building, checking the competencies of the people that are being appointed to carry out those works. And it also might mean building in some additional time for the process of putting the building control application through the building safety regulator.
Okay, that's a helpful reminder. And I think if we assume everyone's doing that and we're all compliant for the purposes of this chat, if we move back to sort of the in-occupation phase, I'll be interested to know from you guys, what do you think some of the key challenges are for owners and managers of the occupied high-risk buildings? What are you guys seeing?
I'll take that one. I think at the moment it's quite difficult to navigate the legislation. I think there's sort of several challenges. And I think part of that is because of how the Building Safety Act was implemented with all the different regulations that sit behind it. So it's not just a case of looking at the specific provision in the Act, it's sort of navigating which set of regulations sort of supplement that. That's quite difficult. Some of the duties that we talked about are quite specific, some of them are not. And where they are less detailed, I think it can be challenging to be really sure of what the expectations are. So to give an example, we could take the requirement around mandatory reporting, for example. So there's a requirement to have a system in place to report safety occurrences. Safety occurrences are very broadly defined as incidents that relate to the risk of fire or structural failure, which, if left unremedied, could result in a significant number of deaths or a significant number of injuries. So one challenge is kind of working out on a practical level what that actually means and thinking about what you actually have to report, because what could be a safety occurrence is very wide. The government guidance does give a bit more clarity on that. It tries to help. So in one of the papers that was published over the summer about the reporting requirements, there were a few examples around things like defects in the building design that were perhaps caused by human error or software, using incompatible or incompliant products, incorrect or sort of installation issues. So, I mean, that's helpful, but it isn't meant to be a conclusive list. We don't have any case law yet to sort of give us further clarity. And it can be difficult to make that judgment call as to whether you've got something you need to report, I think.
I mean, we've already touched on confusion, haven't we? And there being confusion around some of this. And I think one of the issues, again, the four of us are coming up against is that sort of mismatch between what the legislation says on one hand and then government guidance. And I think one topic we're all trying to get to grips with at the moment is how much weight should be placed on the guidance as opposed to the legislation. Would you agree, Danielle?
Yeah, I think that is a key challenge at the moment as well, because where the government guidance does seek to help with some of those sort of grey areas, I think we've got a bit of a question mark now over how much reliance and weight we can put on that. And that sort of stems from a case that went to tribunal in July. So it's called, property in question was called Smokehouse and Curing House. It related to a remediation order. So on its face, it doesn't necessarily seem relevant to the occupation phase. But amongst other issues, they did look at whether the property in question was a higher risk building. And broadly, the property was sort of 6 stories, it seemed. It included sort of, I think it was about 45 flats over 5 of those floors. I think the bottom floor was commercial. And the reason there was a bit of a question mark over whether that was a high risk building fell on the fact that part of the roof was used as a roof garden. And then there was a bit of a discussion about whether that roof garden, which was partly enclosed and partly not enclosed, counted as sort of this 7th story and then took you into the higher risk building territory. So the tribunal looked at that, and I won't go into all of the different things that they considered when making their decision, but they ended up looking at the regulations and the Act and also the guidance and drawing a bit of a distinction between the two. There was a little bit of a discussion about the fact that the guidance seemed to go a bit further than the regulations because it talked specifically about what a story might be. And the tribunal felt that they had to sort of stick more to the wording of the primary legislation. But I think it's really interesting because when you read the decision, they talk about the fact that there's sort of over 50 or so pages of government guidance out there now. They talk about the fact that it can be very difficult to know whether you're looking at the right version, which it is. The fact that pages sometimes disappear without explanation, which they do, and the fact that, you know, in places they try to be helpful, but are they overstepping? And so we've now got some guidance with a bit of a footnote that acknowledges this case, while the government sort of looks at this a bit more, but that does make it challenging.
And does that chime with you, Gemma?
Yeah, I think anyone who has been involved with trying to translate this legislation into practice will have, will recognise some of the challenges highlighted in that case. And although the first tier tribunal's decision is non-binding, the fact that it did make a decision that runs contrary to the published guidance, it's definitely given us all a bit of pause and served as a reminder that the starting point always needs to be what the legislation itself says. We shouldn't be relying solely on those guidance documents. And that said, there is a lot that the legislation doesn't say, and you know, Danielle's talked about the grey areas. For the time being, that government guidance is the best steer that we've got for interpreting some of those grey areas. So, you know, as Danielle said, the government has acknowledged those comments of the tribunal and said that it's considering them, but has expressly said that unless and until stated otherwise, the sector and regulatory bodies should continue to refer to the guidance. So I don't think it's going to be helpful to say we should disregard the guidance. We just need to make sure that we're treating it with that healthy dose of caution, always going back to see exactly what does the legislation say. And I think just having that acknowledgement that it might not always be treated as definitive. And if you're insured to take advice. I suppose in terms of status of different documents, the other piece that I would mention here is the Grenfell Phase 2 inquiry report and the status of that. So we've had a number of questions about that. And what I would say is that although it made a large number of recommendations and we are looking ahead to what might come from that, we are in a position at the moment where we do need to wait and see which, if any, of those recommendations the government will choose to implement and how. For the time being, nothing has changed legally as a result of the publication of that report. But there are some key recommendations within it, such as the change, the recommended change to the definition of higher risk buildings, to the vulnerabilities of residents. And anyone involved in managing higher risk buildings really needs to pay close attention to any shifts in that. So it continues to be an ever-evolving landscape. On Grenfell Phase 2 inquiry, we have been promised a full response from the government within 6 months. So we await that kind of full response, hopefully come March, to see which of those recommendations the government is going to take forward.
And in terms of the recommendations and just the clarity on the guidance point, you know, it's so unhelpful that there is that lack of clarity when the failure to comply is and can be a criminal offence for companies and individuals. There really needs to be a lot more of a steer, particularly on where we can place the weight, because it's just a really key, important point for everyone to be clear on.
Yeah, I agree on that. And if people weren't sitting up and listening, mention of criminal offences usually helps. I think, Natalie, on that theme, it'd be helpful actually to understand what we think the approach to enforcement might be. I think we're some way off, aren't we? Proper enforcement action actually being progressed, but have we got any indicator from the regulator as to how they might approach enforcement?
Yeah, so, well, all the indications from the BSR for the occupation phase is that they're going to be collaborative, and particularly, and it's the broken record now, but where the guidance isn't clear, they should be tolerant to the fact that APs and PAPs, they need that time to understand and adjust to the requirements. And they've also got a statutory duty to assist and encourage relevant people, which includes the Acts and the PAPs, to comply to achieve this safety objective. But that approach is going to evolve, and expectations will change. And even actually, in fact, the latest from the building safety regulator for the building control applications is that they're stepping away from dialogue, and they're just going to be making decisions without engaging with those who are making applications because of the delay. So they're already evolving in terms of approach. And just more generally, in terms of all regulators, they need to comply with the regulators' code. So in terms of taking enforcement action and making their decisions, they need to comply with these principles of transparency, proportionality, fairness. Excuse me. In terms of their own enforcement policy, the building safety regulator have said that they'll be looking at taking a risk-based approach, which I think we would have expected them to. So they're going to be responsive to the highest risk buildings. They're going to be taking into account the vulnerability of the residents, and they're going to be reactive to these reported safety incidents, whatever that captures in due course. So that will be these mandatory safety reports that we need clarity on, but it also potentially could be the potentially the issues reported directly by residents. So that ties in with the resident engagement piece that Danielle mentioned, because ensuring that any issues with residents are able to be escalated, dealt with quickly and efficiently and effectively. You want to be able to do that so you're not drawing in the attention of the regulator with irate residents and tenants. And in terms of the sorts of enforcement action they can take, that again, it's quite a wide range of methods with a couple of new ones thrown in. So they can just have informal action, some advisory information they can provide you with. They can also issue enforcement notices, and they can ultimately decide whether or not to prosecute. And in terms of a new measure, they can also appoint a special measures manager, and that's somebody who would be appointed at your cost to manage the relevant requirements under Part 4 of the Building Safety Act. The Building Safety Regulator is a branch of the HSE. So as an organisation, they are experienced in undertaking these investigations and making the enforcement decisions. And so they'll be using all of that wealth of experience to inform where they go from here.
Okay, that's really helpful. I think just having an understanding about that sort of evolving risk-based approach will really help people, because I'm not, we're probably all guilty of not necessarily looking forward to what might happen when we've got something on our desks. That's really helpful, Natalie. And I guess an obvious follow-up question from me around this legislation guidance enforcement piece is that looking forwards in the next 12 months, what between you are your recommendations with a view to managing and how clients will manage compliance with all of these various regulations and in-occupation requirements?
Well, I think we've talked about obviously the specific duties for principal accountable persons and accountable persons. It will remain key to put those measures in place and make sure that you're getting your strategy and you're getting your report pulled together and all the rest of it. But I think we're going to see a shift over the next 12 months to also thinking beyond that and considering longer term compliance. I think those with responsibility are going to need to start thinking not only what do we need to put in place, but how do we manage that? When do we need to review it? What support do we need to keep it up to date? So in terms of appointing third parties to help with that, do we need to go beyond the initial requirement just to prepare the strategy or prepare the report to, how do we capture things that we might need, like regular reporting or, those reviews, who's responsible for triggering that and how does that review process all work? I know Gemma mentioned it already, but we will need to think about competency. I think that's going to be key because there are lots of entities out there who are offering to support with these services and thinking about how appropriate they are, what their credentials are, and also sort of how you're going to monitor their performance. And I think on that note, just contract governance in general is very important because those are a responsibility. If you are a principal accountable person or accountable person, you can't fully contract and step out of that role. So you do need to be thinking about how you're keeping checks on the third parties you've appointed, and whether you need to build in audit processes and other sort of measures just to ensure that you're protected.
Yeah, it's like compliance with all areas, like health and safety, isn't it? Because it's not just about ticking some initial boxes and then moving on. It's about being able to show this active, ongoing management of risk, especially with a view to the potential consequences. And I just think it's really difficult at a board level, at director level, or any level actually, where where you've got that responsibility for building safety, to get comfortable that you've got the right level of oversight. And so that's not only just, of course, in terms of keeping the residents safe, it's particularly when it's your neck on the line and when it's the reputation of your business.
Yeah, you've mentioned directors there, which is something we don't necessarily always think of, but I suspect we might have some listening in. So, Natalie, how likely is it that a director as an individual would actually be found guilty of a criminal offence in terms of building safety?
Okay, so whether they're found guilty or not will be proved on the evidence beyond all reasonable doubt. It's the criminal burden of proof, that would be for the prosecution to prove. But in the first instance, it's the company that has to be guilty of an offence, which, stating the obvious, the best way to avoid that is to sufficiently manage the risk in the first place. But we've discussed some of the challenges on this today. And then what needs to be established is this wording that appears in the Act, which means that it's the consent, the connivance, or the neglect of an individual, which has to have caused the company to have committed an offence.
I'm going to be honest there, Natty. I think a lot of us are either real estate or construction based people here, and that's kind of, it's going into areas we might not quite have as much understanding around. So what does that sort of consent, connivance, neglect phrase really mean?
Well, so there's no fixed rule as unhelpfully established in case law, but there is other case law that goes into the sort of factors that might establish these things. I would just categorise it as consent being where you've agreed to something. Connivance is where you've turned a blind eye to something. Okay. And neglect is where you didn't actually know about something, but you should have, and you should have been asking the questions about it. And essentially, if you've got any role which covers compliance and management of risk for building safety, and as I've said, it's not just at director level, it's the liability is much wider than that, then you should be asking questions and making sure you've got that sufficient oversight and that you understand what the procedures and processes are that are in place, because that's what the expectation is under the Act.
Mm-hmm. Okay. So I think probably finishing on that topic in terms of the discussion, it's probably a good point. And it's one of those things that, you know, when you think about it, it's a good reminder as to why it's so important to be thinking about this stuff holistically in the way that we've done today. I'm just looking at the time and conscious that we said we'd put some time aside for questions. I wonder if we sort of stop the sort of chat that we're doing at the moment and just turn to those questions. So we can get through some of the topics that are coming up. So if I just have a look, Gemma, you mentioned when you were talking earlier, the Grenfell Phase 2 report. I think people are probably interested in that by the looks of it. And obviously, as you said, we need to wait. But do you think there are any other recommendations coming out of what we're expecting that will have any particular relevance to the in-occupation phase?
Yeah, I mean, the Grenfell Phase 2 report is vast. It's over 1,700 pages, and there's 58 recommendations. I would say the majority of those are specific to design and construction. There's a huge focus on the things that went wrong during the design and construction process and what might be done to remedy that, to the extent it hasn't been done already. But I think for the occupation phase, probably the most key focus is on this area of residents with vulnerabilities. So I mentioned earlier the suggestion or the recommendation that the definition of higher risk buildings is urgently reviewed. And the reason for that is the suggestion is that should in fact not just take into account the height of a building, but also the vulnerabilities of residents within it. So the nature of those vulnerabilities of those occupants. I think at the moment it's difficult to be certain of what that could mean. If the definition becomes dependent on subjective criteria or potentially shifting criteria, it could have a significant impact on which buildings fall within the scope of this legislation. And so change to that really is going to have significant ramifications for the industry and for particularly people managing higher risk buildings. It's also, I suspect, likely to increase the number of buildings being classified as higher risk if it does come to pass, and the workload for the regulator, where we're already seeing that kind of to an extent, overloading of the regulator at the moment with queries and quite slow responses, certainly at the moment. So clarity on that is going to be vital. The other aspect that deals with vulnerabilities is that the inquiry report recommended that the government reconsider this issue around additional requirements relating to vulnerable residents. So the need to have sufficient information about the needs of those residents to aid their escape in the event of a fire. So you might have heard that referred to as a requirement for a personal evacuation plan or a PEEP. And that's one recommendation that actually the new government had indicated even before the publication of the report that it was intending to bring forward, having been recommended initially by the phase 1 inquiry. So the new government has committed some funding to that, certainly in the social housing sector. So I suspect that's something we're going to see coming through with much more focus.
Okay, that's interesting. It sort of brings back home, doesn't it, the overall point of the legislation itself.
Absolutely.
Yeah. So a question I've got, and I suspect some people might be interested because it would come up in terms of sort of corporate real estate transactions. There is this concept, isn't there, around piercing the corporate veil and corporate liability. Natalie, we talked about directors. I was just wondering, what can the courts do in terms of sort of looking to parent companies in terms of liability? So say, if you can't go against the person that you want to, but how widely might the courts interpret that?
So, yeah, and I imagine this will be in people's minds in the context of the Building Safety Act because of the mechanisms it brought in to pierce the corporate veil in respect of civil liability for what are referred to as these associates and associated companies for building defects. And that's with the building liability orders and the remediation contribution orders. But in terms of the criminal liability, the regulator can only bring criminal proceedings against the entity which has committed the criminal offence. So there's no option to go after and proceed against a parent company unless it would be possible to show that the breach was through the act or default of that parent company. So in those cases, it would be something, where they could look to try and establish it by looking, it would be quite an extensive investigation, I suspect, into things like board minutes and actually looking at where these decisions were being made. However, in terms of sentencing, there is some potential for a court to look behind a company to the wider group or parent company circumstances. So, for example, if there was evidence or the inference that an entity which had committed an offence had been given a contract as a subsidiary, as an SPV or a JV, to be created to block criminal and avoid criminal sanctions, then the courts would then consider potentially the parent company and the wider group circumstances to attract a higher sentence. So there is that possibility.
Okay, so again, lots to think about on that side of things. And then I think in terms of wrapping up, because I'm conscious of time, I've spotted a question, Danielle, that I suspect is one for you, and it's around competency and what competency means, because I think that's come up a few times in various answers. I don't know, I can sort of guess what the answer might be, but is there any specific criteria for what competency means in the building safety sphere?
I mean, I think that's a really good example of where the regulations go so far and then the guidance tries to support by adding another layer, isn't it? Okay, so turning first to sort of what the Act says and what the regulations say. We talked a little bit earlier about this general duty to manage building safety risks, and that is supposed to be done in accordance with some prescribed principles. when you get into the detail of the regulations, those require that if you are responsible for building safety compliance, or you're sort of supporting or appointing someone to support with that, you have to make sure that they have relevant competence, which then begs the question, what do we actually mean by relevant competence? The regulations refer to it very broadly as the skills, the knowledge, the experience to perform the functions for which that individual or entity is responsible. So on the face of it, that isn't drastically different to what I would already be saying to clients and what I would already be sort of, expecting them to be thinking about. So whenever you're appointing a third party or a contractor to support you with something, it's good practice to check that they can do what they say they're going to do and that they've got the right levels of skills, qualifications, and experience. But I guess your question was not so general. It was more about specific criteria. The BSA, the Act, it sort of gave the regulator the option to appoint a committee to provide some guidance on this, and they have actually done that. There is a committee called the Industry Competence Committee, and that's been set up to sort of give a bit more clarity and hopefully give some criteria. As far as I can see, they haven't sort of put their name to anything yet, but there was some guidance over the summer generally issued, which they may or may not have been involved in. And that does mention some specific criteria. So that talks about two standards or two specifications by the British Standard Institute. So one is a publicly available specification, and the other is sort of referred to as a competence framework, which might actually be the benchmark framework that's sort of mentioned in the explanatory notes for the Building Safety Act. I won't profess to know the numbers off the top of my head. I'm not that good. But what I would say is the guidance does go on to sort of say reliance on those specifications is not sort of like the only way. It doesn't guarantee sort of meeting legal obligations. So I think what we can say is they'll be influential and they are an option, but I don't think they are the only way. I think it still remains really important to carry out due diligence, ask the right questions, and keep records of the steps you've taken. So yeah, it's one of those where there's a steer, but it might not be your only option and your only route forward.
Got it. That's really helpful. Thanks, Danielle. I'm just looking at the time, but also I've flicked through the questions that have come through and looking at them, I think we've covered off the vast majority of them. And as I said, if anything comes up afterwards that people think to ask, please, you can just let us know. So I think unless anyone has anything else to add at our end, it's probably a good time to wrap the session up. We've covered what we wanted to cover in terms of the conversation. Big thank you to Gemma, Danielle, and Natalie, because I think that was really interesting and hopefully everyone found that really informative. And I think it just shows how quickly you can get into so many different topics on building safety in just an hour. And obviously a big thank you to everyone that's joined and taken the time to listen. I think we all really enjoyed it and hope you did too. As takeaways, I think if nothing else, setting up this webinar as a conversation between us has shown just how far-reaching building safety is. I think we all felt like we could have easily gone off on various tangents, and hopefully we haven't done that. And, you've been able to follow what we've done, but lots to follow up on. As I said at the outset, we've intentionally tried to deal with various topics and issues we're actually coming across on our desks rather than diving into a lot of detail, which we could have done. Not least because I think it's a bit like, building safety is a bit like opening Pandora's box. Once you've done it, so much that can come out of it. So I think in terms of the takeaways that the four of us wanted you to leave the webinar with, first off, we all agree that there's no silly questions when it comes to building safety. We love getting the questions. We'd encourage everyone to keep asking them and to share as much information as you can with us. Secondly, we're conscious that we might not have covered everything that's burning a hole in your desk right now. So please do feel free to contact any of us on this webinar today if there's anything you'd like to discuss in more detail or you have further questions. Or I suppose if any of the conversation topics that we've touched on today have prompted new questions, just ask. We're all more than happy to help. And I'd finish by emphasising Gowling's approach to building safety. hopefully, as we've demonstrated today, our approach is very much a cross-firm one, and it's not limited at all to real estate or construction, and we're not working in silos. Between us, we think that's the right approach because building safety touches on so many different areas, and perhaps areas have come out today that you've not thought about before. So again, if you have a question, but you don't think the four of us are the right people to answer it, then still send it across and we'll make sure we point you in the right direction. We can definitely help. So again, thank you to everyone for your time today. As I said, we've really enjoyed it. Hope you have too. In terms of some final sort of housekeeping admin bits, at the end of the webinar, some feedback questions will pop up at the end. So if you could take the time to answer them, we'd really appreciate it because the feedback really helps us and helps us, form future discussions. And I guess a final plea from the four of us would be if you've enjoyed this, if you found it helpful, if you think there are other people who would find it helpful, then please do share the recording. So thank you from us all and goodbye.